Good morning, Your Honors.
Good morning, Counsel.
May it please the Court, my name is Gregory Hession. I represent the plaintiffs in the Superior Court case below and the appellants in this matter. As you're aware, this case is about the means and the method whereby the child support guidelines were established in the Commonwealth. And the position of the plaintiffs in this case, who are actually 11 individuals affected by the child support guidelines, is that Chief Justice Mulligan, Chief Justice of Administration and Management, essentially enacted a law into place by unilaterally putting the child support guidelines in as the law in the Commonwealth of Massachusetts.
Aren't you actually saying that the legislature could not delegate that?
Yes, Your Honor, that's exactly what I'm saying.
And so aren't you actually saying then that the legislature should have proposed child support guidelines?
Precisely. This is a legislative matter, and the interface between Article 30, which is the separation of powers clause of the Declaration of Rights, which is extremely unambiguous in saying that the judicial department shall never exercise that legislative power.
So just enlighten me. These guidelines for child support weren't the first set of guidelines, were they?
No, the first set of guidelines came into being in 1987.
Did the legislature do what you say they should have done?
No, they did it wrong then, too, Your Honor.
So it's irrelevant, just to follow up on what Chief Justice Ireland is saying. From your perspective, the fact that Chapter 211B, Section 15 was repealed in 1992 is sort of irrelevant because the guidelines never should have been promulgated by any Chief Justice of Administration.
That would be exactly our position. And this is primarily based on Article 10 of the Declaration of Rights that says that any time you deprive an individual of property, and certainly one's money, and this applies to hundreds of thousands of residents of the Commonwealth, that must be only by the legislature. And so the convergence between Article 30 and Article 10, I think, means that the common case for analyzing these Article 30 matters, the Chelmsford Trailer Park case, really wouldn't apply in this case.
But in every case before a judge who has to decide child support, the judge is making child support decisions and depriving someone of property and saying it should be paid to the other caretaker to support the child. I mean, that happens in every case. That's what judges do.
Agreed. But if the legislature sets the process and the procedure and the policy, now this is where I believe that the motion judge got it very wrong.
Well, the legislature set the policy, and that is that the children should be supported by their parents, even if their parents are no longer married or no longer living together. They should be supported by their parents.
That is a fundamental truism, but the actual policies, as in the outworking of how these child support guidelines, both on their face and as applied, don't work out quite that way, because we have a large variety of parents to whom these guidelines apply extremely inequitably. You can have a $20 a week child support order, or you can have a $1,000 a week child support order.
Right.
And they vary even with exactly the same sort of income situation, depending on whether there's public benefits as part of the income, as to whether it's a remarried family.
It is a rebuttable presumption. I mean, isn't that exactly what the judge does, is individually adjudicate whether the rebuttable presumption applies or doesn't apply, and if it doesn't, then figure something else out?
No, they don't do that. These guidelines are applied probably in 99.9% of the cases absolutely rigidly and with no variation. In fact, that was the whole point of putting guidelines together.
But it is by statute, it is by guideline a rebuttable presumption, so that means one can rebut it.
Indeed. But as I point out in my brief, Your Honor, the Supreme Court of Washington really focused in on why it's not possible to rebut it. Because when they calculated these guidelines, they didn't use any cost figures for raising a child, nor did they proportion out what part of these guidelines are attributed to each type of a child-raising expense, such as housing, clothing, food, or whatever. So there's no real guidance, even in the brief information in the deviation section of the guidelines, that would allow a judge to make an objective sort of a waiver of this.
So if the legislature had fleshed out the policy in greater detail, I take it you would then say, well, maybe under those circumstances, the judiciary could promulgate guidelines without offending Article 30?
I don't believe so, Your Honor, because I think that this is so unambiguous, both the language of Article 10 and Article 30 are so unambiguous. The legislature, this needed to start in the legislature, be debated in the legislature, and be passed by the legislature. Both the Boston Bar Association and the Attorney General make much of the fact that this was a very diverse, elite group of people that made this determination. But that's completely beside the point. The legislature is the committee that is supposed to do that by constitutional design so that we don't have elite committees meeting secretly to make determinations like this. There's no accountability of these 11 individuals and of the Chief Justice once this basically becomes enacted into law.
If the legislature had not passed this law, could the judiciary, as a matter of our common law, adopted regulations?
I do not believe so because of Article 10, where it requires a vote of the legislature to take property. And all of our laws which do take property are already subject to votes of the legislature prior to that happening.
But, okay, let's just take Article 10, and you have, I think, where did I read this? From way back, the policy enacted in law that children are responsible, parents are responsible for supporting their children, okay? So the individual judge, as was true before 1986, says, okay, father, you are going to owe $1,000 a week. That's taking property from the father. There's no statute. Are you saying that violates Article 10? Let's just say there's no guidelines. Just individual determination, case-by-case basis.
Given the fact that there was a policy, it's hard to accept the fact that a judge could invent such a policy without a legislative authorization.
Well,
I cannot see
I
it possible.
take it before 1986, wasn't child support done on a case-by-case basis?
Child support was done on a case-by-case basis, and it apparently was not done under the, of course, it wasn't done under guidelines, but I don't see how they really could have gotten around that due process concern.
Well,
Do you
is there a
think-
duty to support your child?
Yes.
There is a duty to support one's child,
A common law duty.
a common law duty.
So courts can enter common law decrees enforcing that duty.
But that's not what they're doing here.
No,
What they're
but
doing,
but
I'm
you said
trying
they
to
could
get
never
back
do
to
it.
your point. Are you saying that they could never do that because you've got Article 10 staring at you in the
well,
face?
that is probably a far more gray question, but thankfully that's not the question. The statute under which this was authorized is repealed 20 years ago, and we certainly aren't bound by a 20-year-old repealed statute. And we have this Article 10 and Article 30 standing as a bulwark against a secret committee doing this sort of thing.
So, since you dispute whether the legislature could have ever have delegated the responsibility for developing guidelines, I don't know where to start the discussion. But presumably, the judiciary did exactly what the legislature instructed back in the late 1980s, precisely constructed these guidelines, did it via the appropriate process. They were implemented, they were used, and the legislature, even though it repealed the statute having to do with how they should be initially promulgated, the legislature constantly in laws has referred to the application of those support guidelines as the proper standard. I mean, why isn't that enough to say that the legislature has and continues to approve the process of setting guidelines?
They do indeed, and you're correct, because they passed the hot potato. What they did is they took a politically hot issue that certainly the legislature didn't want to deal with, if at all possible. We've seen that in reality when some of these difficult things came up. They like to pass the buck if they can. And they passed it to a committee. Then they got rid of the statute and they said, oh boy, that's gone. And now all they have to do is say, use those guidelines. That's not constitutional. It's not lawful, and it's not fair because the public policies that we're now facing that cause a great deal of dissonance between different families similarly situated are terrible because of the guidelines do not address these social policies properly. They left them to the arbitrary determination of a committee. And now we have incredible anomalies. We have second families who are paying for first families up until age 23 to support children, where the first family, if they had not been divorced, would only be required to support up to age 18, for example.
As guidelines always do, I mean, one of the reasons they're implemented is to create some uniformity across the decision-making of many judges in cases that involve a variety of circumstances. I mean, guidelines do create this measure of uniformity, so you don't have anomalies. You don't have one judge who always awards substantial child support far beyond what seems reasonable, and other judges who take a very different view of the relative responsibilities of parents. And the guidelines serve exactly the purpose of evening out that playing field. So why aren't they a good thing?
Well, on that regard, there's a great benefit in having guidelines. These plaintiffs are not against guidelines. Plaintiffs are against the process whereby the guidelines were formulated because the legislature didn't consider the social policy considerations when they put them together. And my brief points out we have about 50 of them literally set up between pages 18 and 28, 50 paragraphs of situations where one family experiences a disparate treatment under the guidelines from another family.
But you would agree, I take it, I mean, it doesn't defeat your argument, but I take it, if the legislature had, in some miraculous way, had come together and been able to pass guidelines, and the substance of the guidelines were exactly the same, you would have no argument, even though it has the same disparate treatment that you're talking about.
If the legislature considered what it needed to do. Now, of course, it has to make a social policy consideration in establishing these guidelines, but here they didn't, and they deferred all of this to a committee. If the legislature made that consideration and passed guidelines, even if they were higher than the current ones, these plaintiffs really would have no due process complaint and certainly no Article 30 complaint to bring before you.
But why isn't it just a legislative intrusion upon, or a legislative interjection upon upon the common law duty of a father or a mother to pay support to the custodial parent? Judges made those decisions all the time, and this is merely a limitation on the unfettered discretion of judges in a common law context.
I do think that's a fair point. But presumably a judge would then do specific fact-finding before making that determination, unlike the situation here where it results in anomalous outcomes of great inequity depending on the circumstances. Public benefits, for example, are not even addressed. And a number of families that are recipients here, for example, could have $40,000, $50,000 worth of in-kind income from these public benefits that aren't even accounted for. A trial judge, however, could take that into consideration, get a full, complete picture of the individual family's situation, and then make a ruling based on that family situation. That actually would be even more comprehensive in essence than a guidelines would do, which has the one-size-fits-all approach.
So wouldn't that be a rebuttal of the presumption?
It would be a rebuttal for the presumption, but the guidelines don't permit the judge to do that, except for 10 very carefully delimited situations that are under a section in there called deviations, and they're very vague, and they don't really provide adequate guidance except for one or two of them to the judge. I think they're badly written, frankly. So,
well, but the judge can make findings that differ from what the guidelines would provide, and I gather that the review of that would be by an abuse of discretion standard.
It would indeed be, but the judge does have to make findings. But the problem is the guidelines already bind the judge with skewed policy decisions that have been made by the Chief Justice in the guidelines themselves. They do not allow for the adequate flexibility, as Justice Spina was saying, under this common law means, where a judge doesn't really have the opportunity to take factual information and make an individual application. Because this was not done and specifying the proper social policies through a legislative process, the guidelines really omit most of that and then bind the hands of the judge to use this sort of ham-fisted approach.
Thank you, counsel.
Thank you very much, Your Honor. I rely on my brief. Thank you.
Good morning, Your Honors, and may it please the Court. My name is Tim Casey. I'm an Assistant Attorney General, and I represent the appellees in this case.
Mr. Casey, what I know you do argue it, but what is the strongest articulation of why the fact that the legislature repealed the Section 15 in 1992 and has never replaced it, what do you do about that?
Well, Your Honor, I think that has to be viewed in the context of everything the legislature has done since 1986 with respect to guidelines.
I understand that there has been amendments to other statutes that repeat references to the guidelines, but it seems to me that the issue isn't that. It's that the actual setting of the standards by which the guidelines were to be promulgated, that was part of the 86 legislation and then has gone. So, for example, let's just say, I mean, I think in this case, the 2006 guidelines have as sort of guiding principles basically the same stuff that was in the 86 statute.
Right.
But what if they didn't? What if they said, you know what, we're not going to do that. We're going to do a whole bunch of other policies and principles are going to guide us. There's nothing that would have stopped them, is there?
Well, Your Honor, the way I look at it is this, and I hope this answers your question. In our view, the question is whether the original delegation in 1986 was a permissible delegation of legislative power under this court's test in Chelmsford Trailer Park.
Let's just assume it was.
Right. There is no requirement under state law that guidelines be revised or updated on a periodic basis. That's a creature of federal law.
Right.
So the question then becomes, has the legislature done anything since 1986 to express disapproval of or to undermine that original delegation of power? And the answer to that question is no. To the contrary, it has continued to pass laws recognizing the primacy of the guidelines promulgated by the Chief Justice in setting child support orders.
Do you think that I'm sorry to interrupt you, but
Sure.
do you think that somebody would have a basis in which to argue? Let's just accept my hypothesis that in 2006 the group chose completely different guiding principles, abandoned those set out in the 86 legislation, and promulgated guidelines. The Chief Justice approved them. They are now in effect. Would somebody be able to come in and say, we understand that the legislature could delegate, but they certainly have to give direction, and they certainly didn't give this direction, and therefore it's either ultra-virus or it's an improper, it violates Article 30 because there is no delegation to do what you've now done, Chief Justice.
Right. I think that would be a stronger case for saying that this either violates the original delegation of power or is ultra-virus, as you suggested. As a matter of fact, in this case, the Chief Justice was very faithful both to the process articulated in the 86 statute in terms of a diverse committee and in terms of the principles articulated and the policy directives articulated in the 1986 statute, making them part of the principles of these guidelines.
So do you think there is no argument at all for, given that this is a common law, it derives from the common law obligation to support that judges then implement, that under rulemaking authority that judges couldn't simply issue guidelines without being delegated that authority?
Your Honor, we don't press the argument that this is part of the inherent part of the judicial power. I think that's a hard argument to make in light of Gray and Brack, in part because, as a matter of fact, judges were doing child support orders for a long time before there were guidelines. Those were the product of statutory directives dating back to at least 1820. I think that's a hard argument to make, but I think there is more than adequate guidance from the legislature and a more than adequate expression of legislative intent by the legislature that they wanted to delegate this power from the legislature to the judiciary.
So again, going back to Justice Botsford's first question, that statute, which specifically empowered the Chief Justice through a process to set guidelines, was repealed.
That's right.
In
1992. Yes.
Is that of no consequence? When the guidelines were then refashioned and reissued in 2006?
Your Honor, it's hard to deny that it would have been cleaner if the legislature had maintained on the books that that 1986 statute, or had amended it to say that the power to promulgate guidelines includes the
continue
power to
on.
revise and review those guidelines. But there's nothing under state law that requires the Chief Justice to do so. Only federal law makes that requirement. And that requirement of federal law didn't come into being until 1988, after the original guidelines were enacted.
But before 1992.
That's right. That's right. But it does not defeat the original delegation to say that the legislature did do this very explicit yet limited delegation of power in 1986. That delegation clearly satisfies this court's standard for analyzing a delegation of legislative power under Chelmsford Trailer Park and similar cases. And nothing that the legislature has done since then has expressed any disapproval or desire to change the arrangement other than
the repeal of the
Other
statute,
than the
which
repeal-
authorized the delegation.
Fair enough, Your Honor, and I can't say with certainty why that happened, but I think the strong inference from what legislative history exists is that repeal was due to the fact that by 1992, the Chief Justice had promulgated guidelines, and there was no requirement under state law that the Chief Justice continue to promulgate guidelines or revise guidelines. So in 1992, when the legislature said we're going to undertake a pretty systemic revision of the state trial court system and revise Chapter 211B, we see that Section 15 doesn't have, Section 15 says the Chief Justice shall promulgate guidelines. Guidelines have been promulgated.
Could the courts have taken a signal from 42 U.S.C. Section 667A, which says the guidelines shall be established by law or by judicial or administrative action? Would that have been enough for the CGM to have promulgated these regulations after 1992?
Well, that certainly should be enough under federal law. Now, plaintiff's argument is that it doesn't matter what that statute says. The state constitution requires hermetic separation of the three functions and powers of the three branches of government. Under plaintiff's view, an agency couldn't make rules or render adjudicatory decisions because it can only execute the laws. That is, this court has said in for example, Gray against Commissioner of Revenue, that while it takes Article 30 very seriously, an absolute division of the three branches of government is neither feasible nor always desirable. And it's hard to see how plaintiff's view of the separation of powers could be reconciled with, for example, Chelmsford Trailer Park, which says power can be delegated as long as it's done with standards and with safeguards on the back end to make sure that the delegated power is exercised fairly.
I'm curious about the public policy considerations that your brother spoke to. And he's suggesting that the guidelines did not consider a number of considerations that should have been addressed. What do you say in response to that?
Your Honor, these guidelines were revised and reviewed during a 2-year process that involved the review of tens of thousands of documents, numerous public hearings throughout the Commonwealth, during which plaintiffs were entitled to be heard. As a matter of fact, now we argue with respect to due process that they had no constitutional right to be heard during a legislative or rulemaking process. But as a matter of fact, they had ample opportunity to make their voices heard during this process. Some of the plaintiffs, according to the complaint, are members of a group, Fathers and Families, that was a plaintiff below. The executive director of that group was on the task force that developed the guidelines, and at the time commended the Chief Justice for conducting a process that was, quote, open and transparent with detailed consideration of the views of its members.
But he did write a minority report.
He did, but for there to be an argument now that this was a secret process and that there was inadequate consideration of diverse viewpoints seems to be undermined by that suggestion that this was a stem-to-stern review that the task force considered at the direction of the Chief Justice. It said to consider every assumption underlying the guidelines and to revisit every issue that's been decided by the guidelines and to make improvements or changes where they're warranted.
Are you saying Fathers and Families participated on that?
They were a plaintiff below, Your Honor. They were not part of the notice of appeal to the appeals court.
But their executive director was a member of the task force.
Is there a basis in the record for the argument that there actually just is no way under the guidelines as promulgated to exercise discretion to deviate, and that it isn't done?
No, Your Honor. In fact, the guidelines themselves make clear, and this is at pages 105 and 106 of the appendix, that there are numerous bases for deviation, and that 10-factor list of bases for deviation is not an exclusive list. So deviations are permissible. There is a requirement that in order for a deviation to be made, the trial judge has to calculate the amount that would be awarded under the guidelines, that application of the guidelines amount would be unjust or inappropriate under the circumstances, and that the best interest of the child would be furthered by deviation. But that doesn't mean that deviations are impossible. So, and this goes in part to plaintiff's due process argument. They have a full and fair opportunity to either argue for deviations from the guidelines incident to discrete child support cases, or to challenge the guidelines incident to, on constitutional or other bases incident to individual child support cases. At least two of the cases that we cite in our brief, the Blix case and the Gray case, are constitutional challenges to some aspect of the visitation or the support regime that originated out of discrete support and visitation cases. So the argument that the probate and family court is somehow incapable of adjudicating constitutional claims, or that they're inadequate to consider challenges to the guidelines is simply not accurate. The plaintiffs will have a more than adequate opportunity to address concerns about the guidelines incident to individual child support cases. And this court has said repeatedly, and for example, the Blix case, that as-applied challenges are the preferred course to adjudicate constitutional challenges to avoid rendering unnecessarily broad constitutional judgments.
Were between the original promulgation of the guidelines and this full-scale review in 2006 to 8, what happened? I mean, every 4 years something had to happen. Were there new? I just don't know. Were there new guidelines every 4 years?
There were, in accordance with federal law. They were not always as broad and as sweeping. There was not always a task force, for example. Sometimes the changes were more minor in scope. So sometimes, like I said, there was not a task force and there was not this full-scale review. In part because of the length of time since the original promulgation of the guidelines and the length of time since a fairly substantial revision and review of the guidelines, the Chief Justice in 2006 decided to appoint a new task force in accordance with the spirit of the 1986 statute and to really conduct a full-scale review of the guidelines. Your Honors, a lot of the disagreement in this case stems from the fact that plaintiffs view the guidelines as insufficiently solicitous of the rights and preferences of fathers. Part of the response to that is those concerns were heard during the process, but that wasn't the principal focus of the guidelines. The guidelines are, of course, focused principally on the adequate support for children. This court said in the Gray case that it is hard to imagine a more compelling state interest than the support of the children of the Commonwealth. That is the guiding principle of the guidelines, and that is what the guidelines are meant to further. For that and other reasons, Your Honors, we would ask that the judgment of the Superior Court be affirmed.
Thank you.
Thank you.